Welcome to this presentation about the rights to a speedy trial. This is not something that I have assigned reading on, but I consider the right to a speedy trial basically to be a component of cultural literacy for any lawyer who's practicing in the area of criminal law and procedure. So I thought it would be worthwhile just to give you this little overview so that you would be aware of it, even though we're not doing any reading on it. One thing to notice right up front is that you'll see the letter S after the word right on this title screen, the rights to a speedy trial. This is because there's really more than one right to a speedy trial that a defendant enjoys. One of them comes from the Constitution, specifically from the Sixth Amendment, and the other comes from statute, because most jurisdictions have passed laws that supplement the constitutional right to give the defendants more rights to a speedy trial than the baseline or the floor that the Constitution itself has been held to fix. So we're going to look at both in this presentation. As always, we're going to start with a little bit of a consideration of what's at stake in the context of the right to a speedy trial. What does the defendant have to gain and lose, and what does the state have to gain and lose? So we'll start with why the defendant cares whether he or she has a speedy trial or not, or when the trial even occurs. Well, the first reason is very duplicative of the kinds of considerations we talked about back when we were considering the right to bail and the right to release pending trial. And that is that the amount of time that passes between when a crime occurs and when the defendant is tried could be time that the defendant is sitting in jail if the defendant has been denied bail or preventively detained. So all of the costs that go along with pretrial incarceration rise up when we consider the question of speedy trial, and all of the hindrances that incarceration poses to the preparation of a trial, as well as all of the unpleasantness that goes along with being in jail. So that's one reason why the defendant cares. Another reason why the defendant cares is that as time goes by, evidence might disappear or degrade in some of the ways we've seen in considering the rights to discovery. People might disappear, people might become unwilling to talk, biological or physical evidence might become unavailable or untestable, or might vanish completely, might be lost through negligence. And if that evidence could be exculpatory or help the defense in some way, then obviously the passage of time is the defendant's enemy, and therefore the defendant might want a speedy trial for that reason as well. Now, what about the state? Why does the state care whether a trial happens quickly or slowly? A couple of reasons here. First of all, sort of the flip side of what we looked at a moment ago having to do with why the defendant cares. If the longer that the defendant is at large pending trial, the longer the state has concerns or might have concerns about the safety of the community and the safety of witnesses, concerns for the obstruction of justice, and all of those concerns that, again, we talked about back when we were considering the right to bail. So that's one reason why the state cares. Kind of in tandem with the defendant, the state also is going to care about the loss or degradation of evidence. Obviously, the state's going to care a little bit more about the risk that inculpatory evidence might be lost or might degrade, but the state, again, has the same kind of reason as the defendant does about the passage of time. And then, of course, the passage of time could incur additional costs. It incurs costs of detention if the defendant is detained pending trial. It incurs costs of surveillance or monitoring defendants that are not detained pending trial. And so, again, the state, all other things being equal, is going to prefer that a case be handled expeditiously rather than that it drag on and on and on. Now, we could also think a little bit about what might be at stake with the inverse situation. Can a trial be too speedy? The Constitution in the Sixth Amendment guarantees the accused a right to a speedy trial, but what would happen if a trial happened too quickly? If a crime was committed on day one and a few days later the defendant was hauled into court and tried. Well, we really can't speak there of a right to a speedy trial because the defendant's certainly getting a speedy trial. But what would happen in a situation like that is that the court would analyze the question under the Due Process Clause rather than the Speedy Trial Clause, and consider whether the speed with which the defendant was brought to trial was violating the defendant's right to fundamental fairness, violating the defendant's right to prepare a defense, impeding the defendant's right to counsel, impeding the defendant's capacity to exercise a whole variety of other trial rights. So, yes, trials can be too speedy, but when they are, that's not a violation of the Speedy Trial Clause. So what is the scope of the constitutional right to a speedy trial? Well, the first thing to think about is a little bit of a puzzle, and that is that you need to think about the remedy. So just take a moment and imagine that a court concludes that too long has gone by between the crime and the beginning of the trial, or perhaps between the arrest of the defendant or the indictment and the time of the criminal trial. Years have gone by. And as a consequence of the passage of that time, the defendant's right to a speedy trial has been violated. What should the remedy to that be? Ordinarily, we think that when a defendant's constitutional rights are violated, the result of that, the conviction that's obtained, should be overturned, and the government should be permitted to try the defendant again without the constitutional rights violation at the second trial. Well, would that work in this situation? Obviously, it wouldn't. A retrial would not fix the problem, because the problem is that too much time has gone by. So to turn around and say the remedy for a trial that occurred 7 years after the crime is a trial starting 9 years after the crime is no remedy at all. What this means is that the courts have concluded that the only remedy for a violation of the defendant's Sixth Amendment right to a speedy trial is dismissal of the charge with prejudice. That is to say, reversal of the conviction and a dismissal of the charge itself with prejudice. By that, I mean without the possibility of retrial. It's an outright wiping away of the criminal conviction and of the charge itself. And because of that, because the remedy is so severe and so sort of ultimate, you might say, that has given an incentive to courts to define the scope of the constitutional right to a speedy trial in a way that is rather, I guess you might say, unfriendly to the defendants or friendly to the state or permissive of long periods of time passing by before the right to a speedy trial is found to be violated. The next question is, when does the right attach, or what's the moment at which you start running the clock under the Sixth Amendment speedy trial guarantee? As always, it's useful to think a little bit about this question in a general way from the question of the values that might be at stake in deciding a question like this. When should the right to a speedy trial attach, or when should the moment be when the constitutional speedy trial clock starts to run? Well, you would tend to think that it should be when the concerns that are animating this principle in the first place really begin to stack up. The concerns, for example, about incarceration and imprisonment and the discomfort and distress that goes along with those things. You might think about the stigma of accusation. When does the stigma that's associated with being subjected to criminal charges, when does that start to crop up? Well, those kinds of considerations have led the court to select as the moment of the initiation of the right, the moment of either accusation or the moment of arrest. So whichever comes later. Now, that still seems a little unsatisfactory in this way. There was a different value that we talked about that the defendant might be concerned about that has to do just with the passage of time generally, and the concern that as time passes, evidence might be lost or destroyed, and the defendant's ability to defend the case might be degraded. And the concerns that would lead the courts to choose the moment of accusation or arrest don't really take those into account. You could imagine years going by between when the crime occurs and when the defendant is actually charged or arrested. And during those years, some of the values that are at stake here might be unaccounted for. With the ticking clock, evidence could be degrading and witnesses could be vanishing and exculpatory information could be disappearing and the speedy trial clock wouldn't be running. Well, does that mean that there's no attention paid to that value during this time period? Well, no, it doesn't. Because remember, there are other clocks that are running, not just the constitutional speedy trial clock. In particular, most crimes have a statute of limitation, a statutorily fixed period during which a criminal charge must be brought. And if it's not brought, it can't be brought. Usually those are terms of numbers of years, but that clock starts to run under a statute of limitations, typically from the moment that the crime is committed. So even though the constitutional speedy trial clock isn't running, the statute of limitations is running, and that has some defense protective effect. Now, you still might be concerned that for a crime that has no statute of limitations, like in many places murder, or a crime that has a really lengthy statute of limitations, that statute might not really provide the defendant with much in the way of realistic protection for the concern that he or she would have about loss or degradation of evidence. So it's not the case that the Constitution has absolutely nothing to say about the passage of time before the moment when the speedy trial clock starts to run. That is to say, the moment of time or the length of time between the commission of the crime and the moment when the defendant is arrested or accused. That time period doesn't matter for the purposes of the speedy trial clause, but there is nonetheless what you might call a backstop protection for extremely lengthy pre-charge delay. And that protection resides not in the speedy trial clause, but again, in the due process clause. There is a due process doctrine preventing excessive pre-charge delay. But, and I suppose this probably won't surprise you at this point in the course, that law is calibrated in a way to make it very difficult for the defendant to prevail. So in order for the defendant to prevail on a claim that there has been constitutionally excessive pre-charge delay in the bringing of charges, such that his or her due process rights are violated, the defendant needs to show that the government was acting in bad faith, and the defendant also needs to show that he or she suffered concrete prejudice from that passage of time. Very, very difficult for most defendants to prove in most cases. So now that we know that the length of time that has to be measured under the speedy trial clause starts to run at the moment of accusation or arrest, whichever is later, how long can the clock run? How long is too long for the purposes of the speedy trial protection under the Constitution? The answer is very, very long. The case law interpreting the speedy trial clause is remarkably permissive of the expiration of lengthy periods of time before the courts will declare a violation of the right to a speedy trial. And remember, part of the reason for that is the remedy. Once the court announces that too much time has passed, it's over. The conviction has to be reversed, and the charge needs to be dismissed with prejudice, and the defendant walks. So this has led to a regime in which very lengthy periods of time are tolerated. The courts use a balancing test of multiple factors. The leading case in this is an old Supreme Court case called Barker versus Wingo, and it identifies 4 factors that the courts need to balance in order to figure out whether too much time has passed after accusation or arrest and before the trial begins. That is to say, before the voir dire of the jurors begins. begins. And those factors are as follows. First, the court looks at the length of the delay. The court will look at the reason for the delay. The court will ask whether the defendant during this long period of time was asserting his or her right to a speedy trial and asking the trial to proceed, or was instead asleep at the switch and seemingly content to let that time pass by. And the court will look to see whether there has been actual prejudice that the defendant has suffered as a consequence of time passing by. As to the first factor, the length of the delay, there is some case law that suggests that after about a year, some modest presumption of concern, some modest presumption of excessive length begins to arise. But you find cases, even Supreme Court cases, that tolerate delays of up to and even beyond 7 and 8 years. And so the most we can say about this first factor is that the longer the delay, particularly the longer the delay after a year or so has passed by, the greater the showing that the government has to make with respect to the other three factors. The court's approach to the reason for the delay, the second factor, is fairly intuitive. The greater the extent to which the court sees the government acting with culpability or you might say bad motive in delaying the trial, the likelier the court is to conclude that the length of time that's passed by does meet the standards of this balancing test and does result in a violation of the defendant's speedy trial rights. So if there's really no evidence of any negligence on the part of the government, if, for example, a witness has gone missing without any culpability on the government's part, that reason for the delay is very unlikely to persuade a court to find a violation of the speedy trial right. On the other hand, if what you have is prosecutorial negligence that leads to this delay, or worse, recklessness, or even some evidence of a purpose to delay the proceedings, that will heighten the court's concerns and make it much likelier to conclude that the government has violated the defendant's speedy trial rights. The third factor, the assertion of the right, is quite clear. Nothing more to say about that one. And then that just leaves the last one, actual prejudice. It's the defendant's burden, of course, to prove prejudice, to prove concrete prejudice from the time that's gone by. And just showing the ordinary things that happen when time passes by are typically not enough. So it's certainly not enough for a defendant to come in and say that during a 5-year delay, memories degraded in the way that all human memory does as time passes by. The defendant needs to be able to show some specific piece of evidence would have been available and would have been helpful had the trial occurred promptly and is now unavailable because of the passage of time, especially because of the government's, as I say, government's negligence or the government's efforts at delay. So if, for example, you have a 5 or 6 year period, much of which might be attributed to negligence on the part of the government, and where where a witness who was sick actually passes away, that might be enough to satisfy the actual prejudice standard, particularly if you can show, as the defendant, that the witness was somebody whose testimony would have, in some identifiable way, been helpful to the defense. So generally speaking, this Barker versus Wingo balancing test is a tough one for the defendant to meet. Because of that, legislatures have passed statutes that confer additional rights on the defendant as a matter of statutory law, not as a matter of constitutional law, but as a matter of statutory law. So a couple of years after the Supreme Court decided the Barker versus Wingo case, Congress passed the Speedy Trial Act. And that federal law guarantees the defendant a trial within a much shorter period of time than the Constitution does. In fact, it guarantees that the defendant will be tried within 70 days of the later of his or her first appearance for a judicial magistrate or before his or her indictment. Yeah, that's right, 70 days. Now, you might think, wow, that's really giving some teeth to this principle of a speedy trial. But as it turns out, it's really not so much the case. First of all, the Federal Speedy Trial Act has a long list of events and activities that happen during a typical criminal case that are exempt from the counting of that 70-day period, or that toll the running of the period in the language of the statute. So, for example, the filing of a pretrial motion will toll the running of the statute. And while that pretrial motion is pending, all of the days that pass by will not be counted for that 70-day period. Similarly, if the defendant has to be examined, let's say, for mental competency or some other purpose, the period of time during which that happens will toll the running of the Speedy Trial Act, and those days will not be tallied up to that 70-day total. But most importantly, the statutes leave the judge significant discretion over what the remedy should be for the violation of this 70-day rule. And those remedies that are permitted include a dismissal without prejudice. And in fact, there's a Supreme Court precedent that says that that ought to be the preferred remedy. Now, think about that for a moment. If the preferred remedy under the Federal Speedy Trial Act for a violation of the 70-day rule is a dismissal of the charge without prejudice, what's the government likely to do in the event that the court concludes that the Speedy Trial Act has been violated? Well, it's going to bring charges again, and the 70-day clock will start all over again. So in a lot of respects, this Federal Speedy Trial Act is a fairly toothless remedy. It's extremely rare for trial courts to use the Speedy Trial Act to dismiss a charge with prejudice, and it's also extremely unusual for appellate courts to conclude that a judge has abused his discretion by ordering a dismissal without prejudice as the remedy for a violation of the Federal Speedy Trial Act. So the Speedy Trial Act does have some modest impact on the pace with which things occur. It's burdensome and it's a nuisance for prosecutors to have to start over again. But it's nothing like the harshness of the remedy under the federal constitutional guarantee, which is an outright loss of the ability to proceed against the defendant at all. So there you go. There's a brief overview for you of the speedy trial rights that a defendant has under the Constitution and under the Federal Speedy Trial Act. Most states have some analog to the Federal Speedy Trial Act. So most defendants in most places have multiple speedy trial rights, but they don't guarantee a trial that's particularly speedy.